Thank you, Marshall Crawford. Good morning and welcome to this oral argument session of the Sixth District Court of Appeal. I'm Judge Keith White, and I do have the honor of serving as the presiding judge here today. Serving with me today, on my right is Judge Petra Brownlee, and on my left, Judge Roger Ganem. Just a reminder, we are being video and audio recorded here today with both of the cases. So please silence your phones and other electronic devices. Also, just for your information, the broadcast is on YouTube. We have a live stream and also would be available for other people who maybe weren't able to attend who would like to watch that at a later time at their convenience. All right, our first case on the docket today is 2024-0130, Gossage v. CSX Transportation et al. Counsel ready to proceed? And counsel, how much time would you like for rebuttal?
I would like to reserve 5 minutes if I may.
That's fine. All right, whenever you're ready.
Good morning, Your Honors, and thank you, and may it please the court. My name is Jeff Mansell. I represent Heather Gossage and the estate of Larry Gossage in this appeal. We ask that the final judgment be reversed because the record establishes issues of material fact that cannot be resolved by summary judgment. These issues include who had possession of the railroad crossing at the relevant time, whether there was an effective delegation of maintenance responsibilities at that crossing, and what the cause of this motorcycle accident was. The trial court drew 2 conclusions in its order on summary judgment, which are relevant to this appeal. The first was that the railroad owed no duty to Mr. Gossage because it effectively delegated the maintenance responsibilities of this crossing to Polk County. The second was that the expert for the plaintiff, Mr. Fisher, and Mr. Fisher's opinions were insufficient to create an issue of fact because they were based on the stacking of inferences. We, of course, contend that both of those conclusions were wrong. Beginning with the duty, there are factual questions in the record of who had possession of this crossing. That is the first issue. Under Florida law, the duty in a premises liability case falls on the party who is in possession of the premises. And the Bovis versus 7-Eleven case, which was cited in the railroad's brief, establishes the test or sets forth the test for how we know who possesses property. And it comes down to who occupies it, who controls it. If nobody is presently occupying it, who has the right to occupy it and exercise control over the property. And under that,
Mr. Mansell, I wanted to ask, do I interpret the trial court's order to simply decide that the contracts themselves govern this question? In other words, we can get the answer. I think the court said they speak for themselves. So do we need to know more than what's on the face of the 2 agreements, the 32 and the 02 agreements, to decide this question, or is there factual information outside of those agreements that we need to look at?
there is factual, thank you, Your Honor. There is factual information outside the agreements. And in particular, it is the testimony of Polk County's corporate representative who testified that the agreement from, decades ago, whenever it was in the 1920s or 1930s, did establish an undertaking by the county to maintain the property. There's a separate agreement that I think was entered into in 2001, which Polk County contends actually removes any maintenance obligation from Polk County. And then there's the testimony, I believe it's still from Polk County's corporate representative, that they actually did not have control over the premises because they could not enter the premises at will. They had to have permission from CSX. And in fact, if I remember correctly, from 2001 onward, Polk County did none of the maintenance itself. Instead, CSX performed the maintenance, and Polk County's responsibility was limited to paying for the maintenance of it.
If let's say the contractual arrangement between CSX and the county required the county to maintain some part of that crossing, let's just say, for the sake of argument, up to the actual rails themselves, but CSX voluntarily undertook the maintenance of the whole crossing. In other words, undertook maintenance outside of the rails. would that determine as a matter of law their responsibility or a duty owed to Mr. Gossage in this case? Or would the legal language in the contracts control?
I would say, Your Honor, that the actions of Polk County would control, or I'm sorry, the actions of the railroad would control for two reasons. One, because there are two potential sources of duty here. There's the duty imposed on the party in control of the premises, and there's a duty imposed by an undertaking, whether that undertaking is by contract or gratuitous or otherwise. So CSX Transportation would still have the duty under the scenario that Your Honor just gave me. Under both theories. One, because it is a premises liability case at heart, and the duty in a premises liability case falls on the one with control over the premises. CSX Transportation retained the right to exclusive possession and control of this premises at all times. Even under the license agreement, it could kick out the county under the terms of the license agreement, say, can't use this as a crossing anymore. Second, in your scenario, Your Honor, the railroad would have undertaken to maintain the property by actually performing the maintenance, whether it was gratuitous or whether it viewed it as its obligations under its agreements with Polk County. It would be an undertaking. It would be the railroad deciding that it is going to maintain this area of the crossing, both within and outside the rails. And what that would mean was, by undertaking to do so, it had an obligation to exercise reasonable care in how it carried out that undertaking. Yes, by the railroad voluntarily performing maintenance, it shows a duty under both the general premises liability theory and under the undertaking theory.
So based on the causation opinion of Mr. Fisher, does the plaintiff contend that it is CSX is fully responsible here, or is it some combination of CSX and Polk County? And how do we decide that?
We believe that it's a combination, and it goes back to, I'm sorry, this left turn is wobbling on. This goes back to my answer to your previous question, Your Honor, about the sources of duty, because we believe that the railroad has the primary obligation as the one in control of the premises, but that because Polk County acknowledges its undertaking with regard to the design and maintenance of this crossing, at least portions of the crossing, that there are parallel duties in this case.
So you mean that the county, even within the rails? I mean, because my understanding was that it was, okay, if it's outside the rails and there's the slope, right? That then would be the county. But what you're saying is I'm misunderstanding that. And it's both CSX and because of the undertaking, it's the county within the rails.
That's a good clarification, Your Honor. Thank you. No, it does appear that the county's undertaking was limited to the portion of the paving going up to the first rail and then after the last rail, which isn't at issue in this case.
Was it up to the first rail or up to the first end of the tie?
Up to the first end of the tie, which isn't very far from the first rail, but yes, to be precise, Your Honor, you're right, up to the end of the first tie.
And was Mr. Fisher's testimony that, or is it Dr. Fisher? I apologize.
It's
if
Mr. Fisher.
Okay, Mr. Fisher, that there's a problem with this. I mean, I understand about the standards and the argument about the slope, but with regard to the braking or anything that might have gone wrong there, aside from the slope, is it Mr. Fisher's position that the problem was before, such that it would have been the county's duty, or is it after, and then because of the slope within the rails?
So Mr. Fisher, he doesn't really give an opinion on whose duty it was. I mean, he looked at who owned it and.
But we're to gather that just from the location is my understanding.
Yes, Your Honor, and the property records and the contracts and the testimony. And it might be good to just summarize and paraphrase what Mr. Fisher's opinion is.
Okay.
Because it has to do with both the portions that lead up to the railroad contends with Polk County's responsibility and the portions that are unequivocally the railroad's responsibility. So Mr. Fisher's opinion is that there are a couple factors that had to coincide for this accident to happen, for this crash to happen. Approaching the crossing, there is an uphill grade and everybody brakes. I mean, any motorist would brake going up that uphill grade toward a railroad crossing. Sensible people do not accelerate or maintain their speeds going over railroad tracks. So everybody agrees, Mr. Gossage and everybody else were applying brakes. And as they're going uphill, of course, the application of the brakes causes the weight on the motorcycle to shift forward around the center of gravity. So under normal circumstances, you apply the brakes, weight shifting forward. Now, what Mr. Fisher refers to as the geometry of this crossing creates a ramp going up to that first rail. So as you crest at that first rail, on any vehicle, it'll remove some of the weight that's being shifted to the front, and that's what it refers to as a decompression. The grade then shifts downward between the first two rails, and when the front wheel then makes, the weight comes back down, there's a drastic compression at that point that wouldn't happen just from braking. It has to involve the geometry of it. So then by suddenly compressing the weight on the front wheel, it causes it to bounce, and there's a compression, decompression going on, which causes the skip skid, as the experts keep calling it, at this crossing. So then the grade once again shifts upward, going from the second rail to the third rail, the second set of tracks. And then because it's going uphill, as it's kind of skipping, compressing and decompressing, the weight goes all the way back on the front wheel. There's full compression on the front wheel. It completely locks up, and that's when he washes out.
So the problem begins with the slope.
Yes,
So
Your
it's
Honor.
outside and then continues and under your theory and crosses through the tracks.
Yes, Your Honor. There's an interaction of all these changes in grade, what Mr. Fisher calls the geometry.
So then we don't really need to resolve, is it true under your theory that we don't need to really resolve duty with regard to inside the rails and duty with regard to slope and outside the rails in order to determine whether there's a disputed issue of fact? Like, and that might not be stated very clearly, but if we agreed with you hypothetically, then they would both have duties, right? There's this coexisting duty because the beginning of the problem and the end of the problem.
Yes, Your Honor. Yeah, and that was going to be part of my spiel on the duty, that, there are disputes about just how far CSX Transportation's control extends, but there is also a dispute over, all of the interactions of all these portions of the crossing that were unequivocally under the railroad's control and unequivocally part of Polk County's maintenance obligation.
Counsel, my understanding is that your client's contention as part of the duty of both the county and CSX is the duty to maintain. Is that correct?
Yes, Your Honor.
Well, when I read Mr. Fisher's relevant portions of the deposition cited by you and your opposing counsel, as I read his testimony, when I heard geometry, that to me seemed to be a design issue, not a maintenance issue.
Well, so yes, Your Honor, I suppose there are both design and maintenance elements of this. But in maintaining the crossing, both the railroad and the county can mitigate these geometric effects. And
Where is the basis of that in the record? What you just said, that argument you just made.
I think,
For example, and maybe this will help because I don't want you to get a puzzled look, so maybe my question is not clear. So if you have, say, the road up here 30 feet out, use that, your expert used that from the center line of the rail. So you say you're 30 feet out, and say the elevation from some basis point is 100 feet. And the rail's down here at 5 feet. You would agree with me that from a geometric standpoint, there's going to have to be a decline, correct?
yes, but you can mitigate the effects of that by adjusting the grading through fill and through pavement.
Which is design, design and or construction.
Yes, but you can do that by changing it after it's initially designed. So, and maybe I'm misunderstanding your question, but this doesn't all come down to the 1922 design of the crossing. When there's maintenance in 2001, I believe, and that's partially in response to an FDOT inspection, if I remember correctly, that identified problems with geometry. Part of the point of going back into the site and repaving or performing maintenance is to address
That 2002 agreement that you referenced.
Is
Is that what you're referencing, the 2002 agreement?
I was referencing Mr. Fisher's testimony about his review of an FDOT inspection and some subsequent repairs and maintenance at the crossing. which,
I mean, the 2002 agreement refers to construction, reconstruction, or otherwise changing a portion of the public road.
okay, yes, Your Honor.
And that indicates that that's an FDOT project.
I think you're right.
So it means they were doing the design and construction. Is that correct?
I was under the impression that CSX Transportation actually did the work.
Did the work or maybe had some obligation? There is some cost shifting in here in this agreement that I saw.
My recollection of the record is that CSX Transportation did the work and Polk County reimbursed it for the costs.
Okay, so I guess what standard is it? Because I certainly, I think you gave a very good summary in terms of your expert's testimony about how the loading on the suspension, et cetera, changed because of this decline and incline, then another accepting your expert's testimony and the light most favorable. Okay, there's this undulation, I'll call it. But where is this, and I did see the standard about it being on the same plane and the difference in elevation of plus or minus 3 inches, 33 feet out. But where is the standard in terms of the design of the road? If you're saying that this road was constructed at, well, I guess first, where in the record is that CSX and or Polk County constructed or designed the road or assumed the obligation to do so? I didn't see it, but maybe I'm.
Yeah, and Your Honor, I apologize, but this, this wasn't really the argument at summary judgment. So I didn't familiarize myself with part of the record that you were asking about. Summary judgment was really turning on, can the expert say this? Does the court have to accept it, and who's in control of the premises? And neither defendant raised the issue of, well, it wasn't even us who was responsible for this in the first place. Nobody put it on FDOT to establish these grades. So,
Well, I mean, my understanding is the issue was maintenance, but I thought both defendants did argue that there was no insufficient evidence to show that there was negligent maintenance. Maybe I
consider their argument to be that there was insufficient evidence that it was in a dangerous condition, which is different from saying we weren't the ones who did this at all. It was FDOT, and the evidence. The evidence from Mr. Fisher was that it was in a dangerous condition. So, Your Honor, in my time listening to opposing counsel, I can glance at the record. I'm not sure I'll be able to answer your question today about how it is that these grades came about, because it seemed to be accepted that it was either Polk County or it was the railroad that was responsible for what we call the geometry of the crossing. And that, as far as I could tell from the motion and the response, that point was undisputed. And in my rebuttal time, fairly severely, Your Honor. So
No, that's I asked you for a question, and that I'll give you some time to account for that. Any other questions?
thank you, Your Honor.
All right, thank you, counsel. And have the appellees determined how they're going to allocate their time?
Yeah, Your Honor. Dan Fleming on behalf of CSX Transportation. I've spoken to counsel from Polk County, and we've allocated the time 15 minutes to me, 5 minutes to Polk County.
One second. Said 15 for you, correct?
Yes, sir.
All right. All right, are you ready?
I am ready.
Go ahead.
May it please the court. Dan Fleming of Johnson Pope on behalf of CSX Transportation, Inc. The judgment of the circuit court should be affirmed. Judge Raful's detailed 12-page, it's actually a single-spaced order, so it's really like a 25-page order granting CSX Transportation's motion for summary judgment and setting forth the reasoning he utilized in arriving at his decision in direct compliance with Florida's new summary judgment law as of 2021. Should be affirmed for 3 reasons. the first, and the real, all three separate reasons, I think. The last two kind of dovetail together, but the first one, every single allegation of negligence relating to sections of the highway grade crossing for which CSX Transportation is demonstrably not responsible. Every single allegation is outside of what CSX is responsible for. And contrary to what you heard in some of the briefs and what you heard in some of this argument this morning, the record evidence is completely devoid of any evidence that CSX had any responsibility outside the ends of the ties, as Judge White pointed out. It's not the end of the rails, it's the end of the ties, which extend about 18 inches beyond the rails. So you basically have, if you're familiar with, everybody's kind of familiar with tracks go like this, the rails are perpendicular to the rails themselves. They extend about 18 inches beyond the ends of the rails. That is the sole area of maintenance responsibility that CSX has at this particular crossing.
Council, if I can interrupt
Sure.
on one point. The railroad ties, and you look at the different schematics, you can see them, and they, by definition, they tie the rails together. So they go perpendicular. The rails go like this,
Correct.
the ties go like this. But then there are these pieces, and the evidence is replete with reference to these pieces of wood, the wood timbers that parallel the rails. Now, are they coextensive in terms of the edge with the edge of the tie? Because that wasn't clear to me from the record.
They are. If you look at the photographs, and if you look carefully at the photographs, you'll see they all come together. I mean, the area of maintenance is, and this is the most important, critical point of this case relative to this first point. There is no dispute in the record, none, not one single piece of evidence in this case in the record indicates that CSX had any responsibility outside the ends of the ties. And that is,
So let me ask you,
Sure.
on that point,
yes, sir.
because we're dealing with, I think in the premises liability question, we're dealing with control, not necessarily responsibility. And so if when you make your point, you would address in the 2002 agreement, on the third page, or I guess it's the second page, it's paragraph 3. It says that the CSX will maintain at its expense the track and rail components and highway surfaces for the area of the crossing between the ends of the railroad ties. And the county shall be responsible for the maintenance and costs of the highway roadbed outside of the railway ties. So far, that's what we're talking about. But then the next sentence says, it being expressly understood and agreed that CSX may, at its option and upon notification to the county, perform such periodic maintenance work and bill the county directly for costs thus incurred that are the responsibility of the county. And I read that to mean CSX might only be responsible for what's between the ties, but at its option, it can do more and just send the county a bill. Why is that not control beyond the edges of the railroad ties?
Well, because it's plainly not, and there is zero evidence in the record, not one shred of testimony, not one document. That interpretation is, with all due respect, Your Honor, wrong. The particular.
Well, it's what it says.
Well, let's go to what it actually says, because if you look at the actual two agreements, paragraph 2 of the 1932 agreement specifically requires Polk County to construct and maintain the highways upon CSX Transportation's right of way. Nothing in the 2002 agreement negates that obligation. I'll go directly to the portion you read from. Paragraph 7 of the 2002 agreement expressly provides that any provision contained in any existing contract relating to said crossing shall remain in full force and effect except as otherwise provided herein. Thus, absent clear and explicit language to the contrary, which does not exist, the county's duty to maintain remains intact. And if that language of the both contracts are very consistent with regard to this, it's a very common, normally the contracts are with FDOT, with a municipality, in this case, Polk County. These are very common contracts. It's what we look at every single time. I've been doing this for decades. When there's an accident, the first thing we go look at the agreement. This agreement is standard. It's very easy to interpret. The idea that we can bill them, again, remember, the tracks are there first. We own the property. We have a railroad crossing there. They're putting a road over it in 1932. The language that you're referring to allows the railroad for any work that it has to do because of, again, work within the ends of the ties that they have to do. They bill the county because that road we wouldn't have to do that work. Ostensibly, the maintenance that we have to perform at a crossing is much more extensive than down the tracks when there's not a road with cars going over it all the time. in that particular area, when we do work, we bill the county and they pay us. Otherwise, we close the crossing. That's what the evidence shows. There, again, and this is critical, there is no evidence in this case, despite what you see in some of the briefs and what you've heard today from the podium from opposing counsel. There's no evidence in this record that CSX ever did any maintenance outside the ends of the rails, consistent with the language in both agreements. And if that wasn't clear enough, two people in this case have testified. The two corporate representatives from Polk County and CSX, both of them testified completely consistent with what I just told the panel.
But that's not what the trial court found, right? The trial court finds a wholly separate issue with regard to duty. I see you're puzzled by it, so
I am puzzled, yes.
with regard to the subservient estate and the dominant estate, and when there is a non-delegable duty, it just seems to me that I think that what you're saying is consistent, right? Like I'm following you with regard to the agreements and the testimony. But what I'm concerned about is the trial court's finding with regard to duty and why he is saying that your clients don't, or that the county and CSX has no duty in the case.
I don't think he said there was no duty. I think he very specifically acknowledged what the agreements say is that CSX's duty was confined to the area between the rails. And that's where I'm going with this whole point. I think it'll bring it home for you, is irrespective of what the county now says or what counsel says here in argument, there's no evidence in the record that our responsibilities go beyond the ends of the ties. And then to tie it together, there's the record evidence in this case is equally clear that there is no allegation of negligence within that area. As you're
Within what area?
within the ends of the ties. All the evidence of negligence is 30 feet back and 2 feet back. And that comes directly from plaintiff's expert, Mr. Fisher, who testified conclusively. And he was specifically asked, what about the area between the ties? I didn't look at that area. My testimony is about 30 feet back and 2 feet. Again, both of them outside. Again, remember, the ties extend about 18 inches beyond the rails. 2 feet is outside of CSX's responsibility. If you believe those allegations are correct and had anything to do with the accident, which is again, obviously contradicted by the common sense notion that you had 6 riders, you've had no prior complaints, you've had no prior accidents, you had 6 riders riding normal motorcycles on that particular day, not a chopper motorcycle with only 3 months of experience. They traversed the crossing without incident. And again, that's what the evidence shows in the case, not what people are now talking about. Well, my impression is CSX was doing this, or there's no evidence in the record. CSX's responsibility was confined between the ends of the rails, and the allegations of negligence are outside of that area.
What about Mr. Fisher's testimony, and correct me if I'm wrong, that there was a downward slope past the first rail and then an upward slope again before the third rail or the next set of tracks? Isn't his testimony that there was a problem with the grading in between the rails?
Yeah, in between the rail, again, you got 4 rails here, so it's a little confusing, understandably. But no, first of all, it's not Dr. Fisher or Mr. Fisher's testimony in that regard. That's what is argued in the brief. And they talk about it, if you look at it, it's confined to, because they didn't refer to Mr. Fisher's testimony regarding that point because they couldn't, because he didn't testify about that. Again, look carefully at the record. When I asked Dr. Fisher, what about the areas specifically between the ends of the ties? I didn't find an opinion specifically about that area. The area you're talking about is between the 2 sets of tracks. So between the second and the third rail, and that's where they talk. Again, you've got 2 sets of tracks here, which is where the county back in 1932 decided to build a road. You got 1 track here, 1 track they're not exactly, on an even keel. So it necessarily is going to have to be a grade between there. That's not a violation of anything. Again, I don't want to go, it's a red herring to go down the whole statute, because what the court found, and going back to your question, Judge Brownlee, what the judge found was not that there was no duty here. It's that the duty of maintenance cannot be connected to any allegation of negligence or causation in this case. Again, all he's saying, and here's where you really get down to the second point. The first point is all the allegations of negligence are outside CSX's responsibility. That's in and of itself, and the story affirms. But even if you get beyond that point, then you go to the actual opinions Mr. Fisher formed, and they were clearly based on an inference. You don't have to wonder about it. All you have to do is look at Mr. Fisher's testimony. He acknowledged that there was no testimony from anybody about how Mr. Gossage braked his motorcycle. Zero, no testimony. He had to infer and did infer based on Mr. Mortara's testimony. He was the one guy behind him. Again, they're driving staggered over this railroad crossing. Everybody traverses it safely except for Mr. Gossage, who's driving a different type of motorcycle. He's only been on it for 3 months. He brakes 30 feet before he even gets to the crossing, starts to skid, loses control, falls down somewhere around the crossing. Again, the evidence in this case is that Mr. Gossage fell near a railroad crossing. There is no evidence in this case that he fell because of that railroad crossing. And that's what Judge Raful determined. And if you look at his opinion, he did exactly what the Florida Supreme Court. I go back to, math when you were a kid and you're doing your math. Remember when you had to do your math and you couldn't just write the answer down? You had to show your work. Well, Judge Raful shows his work. If you look at paragraphs 23 and 25, all this nonsense about, Judge Raful was acting as a battle of the experts, or he's trying to substitute, you become a fact finder. That's not what he did. Look at the language he used. In paragraph 23, he begins it with, the experts agreed. He didn't base his opinion on anything they disagreed about. He may have put that in the order, but what he actually ruled upon, and you can see it in his ruling, he said what they agreed upon. What Judge Raful did was he did look at the evidence in the light most favorable to plaintiff by only relying on evidence that the experts agreed on. They agreed they break 28 feet back. So the only thing was, Judge Raful said, well, how do you get around the fact that this guy braked differently than everybody else? And that just caused the accident. No answer for that, zero. And that's why you get to the food fair case, but I don't want to get too far ahead of myself. When you look at Tim Mortara's testimony, I mean, please.
Counsel, if I could stop you on that, but
Sure.
But why is that the plaintiff's burden to show that he braked properly?
Well, because specifically under Florida law, if you can't, because if he braked improperly, that, and it
Sounds like comparative negligence.
No, sir.
No?
It goes directly to, if you look at Mr. Fisher's testimony, he was specifically asked, could Mr. Gossage's braking be the cause of this accident? He said, yeah, it could. But Mr. Fisher disregarded that and came up with this theory of the relatively flat crossing having all these up and down motions. The fact that he acknowledged it could have been the sole cause and couldn't exclude that, that's where you get to Florida law. This is a Supreme Court case. Food Fair very specifically says that if you've got a reasonable inference that could have caused the accident, which Mr. Fisher specifically agreed could be the case, you have to be able to reasonably exclude it. He couldn't do it. He didn't do it.
Do you acknowledge, counsel, that the rule is somewhat different with regard to expert witnesses for stacking inferences?
Different in, yes, if they're only, yes, obviously it is, if the expert relied on direct evidence for his opinion. And that's what you don't have to wonder about, because I specifically asked Mr. Fisher. Mr. Fisher was asked. He clearly is infirm. I mean, if you look at Mr. Mortara's testimony.
He's allowed to infer, right? I mean, he's an expert witness.
Well,
So he can't speculate wholly, right, under the case law.
He can't speculate wholly, and he can't completely infer. He has to have, unless that inference is raised to some level of fact, and that's clearly not the case here. If you look at Mr. Mortara's testimony, look at the language he used.
So do you not think testimony is evidence?
It could very clearly be evidence. Let me make sure you understand what I'm saying. If Mr. Mortara had said, I saw Mr. Gossage's braking, and I believe it was reasonable because I saw it and I knew, he didn't say that. Mr. Mortara doesn't give any evidence regarding. He said, again, look at the testimony of Mr. Fisher. He's not relying on Mr. Mortara's testimony. If he did that, you're correct. Then it would be, he's relying on direct testimony. You can rely on testimony. You can infer from testimony, but you can't make an inference about testimony and come up with your opinion if it doesn't exclude other reasonable inferences, which his clearly doesn't. Look at what Mr. Mortara's testimony is about speed. He doesn't testify. First of all, it's important, critical. He didn't testify about how Mr. Gossage braked. Again, he's not relying on Mr. Mortara's testimony about how Mr. Gossage braked for him to come up with the opinion that Mr. Gossage braked appropriately. He's relying on Mr. Mortara's testimony about how he came up upon him about speed. And he said, I don't know, I was coming up about the same speed, kind of close. I'm not really sure. Didn't really look at that. He doesn't have any testimony about how Mr. Gossage braked. He had to and necessarily did infer from Mr. Mortara's testimony that based on the fact that Mr. Mortara couldn't remember how much he was coming up on him, then Mr. Gossage must have braked appropriately. That's an inference. You can't start with an inference and stack them. That's specific what is impermissible stacking of inferences. You have to start with
Counsel,
the
I'm sorry.
fact. Yeah.
Has he answered your question or?
That's
you-
fine. Yeah, go ahead.
Okay. Any
I had
other
one
questions?
more, and maybe we can give some more time to,
We will.
to the county. As an expert witness, would it not be appropriate for Mr. Fisher to give an opinion that assuming normal braking, it was the condition of the crossing that caused this accident? And then let the question of whether he braked normally or improperly be submitted to the jury. Why is that not appropriate for an expert witness to give an answer to even a hypothetical question that assumes appropriate braking and gives an opinion about how the crossing caused the accident?
Well, I'll start by saying that's not what happened. But your question, could that potentially be something that could go to a jury? Maybe, but it didn't happen here. And specifically what did happen here is he inferred, and specifically, if you look at what Judge Raful did in paragraphs 23, 24, and 25 of his order, he specifically looked and said, look, you can't exclude the fact that what they're saying actually occurred. He didn't pick one expert over the other. He just asked, can you exclude this reasonable inference?
But isn't the question here whether a jury could conclude based on Mr. Fisher's opinion that the crossing or the condition of the crossing caused the accident? It's not up to the plaintiff to exclude every other possibility. It's simply the plaintiff's obligation to put forward some evidence and then let the finder of fact
It's
decide.
not the case anymore. I respectfully would disagree. It is very, if you read the food fair case, it is very specifically the plaintiff's responsibility to exclude any reasonable inference that has been presented.
You're talking about the stacking of inferences question, right?
Well, it's both. And that was gonna be my third thing is the food fair case. The stacking of inferences is impermissible. That can't be the cause that you submit to the jury, where you're asking them to just pick the one that we speculate about and not one that you have to be able to exclude any other reasonable inference. And clearly, in this factual scenario that presented here to Judge Raful, there was a reasonable inference that Mr. Gossage braked too hard. In fact, their expert agreed it was potentially the cause of the accident. He just came up with a theory different than that. But to do that and to submit it to the jury, getting directly to your question, you would have to exclude other reasonable inferences, and they couldn't and did not do that here. That's the third reason that affirmance is absolutely mandated. But all of your questions go to.
Counsel, I'm sorry. Has he
Yes.
responded to your question?
Yeah,
Anything else? All right. All right. Thank you, counsel.
Thank you for your time. I would rely on our brief for any questions we didn't ask or anything that were raised on in rebuttal. Thank you.
Thank you.
For
1 second, counsel. Afraid this is above my pay grade.
Well, I'm not gonna talk for very long, but
I'm trying to get your 5 minutes set up here.
Yeah, you're going down. Go down.
All right, let's go with it.
okay. Thank you, Your Honor. I'm John Trone from Lakeland on behalf of Polk County. I ask that the judgment be affirmed based on the speculative nature of the proof that was offered. I'm here to speak a little bit further, though, on the part about scope of maintenance, only because I don't want to be railroaded, as I think.
Did you practice that, counsel?
It occurred to me on the drive from Lakeland. I said, I gotta work that in. But as your Judge Gannon mentioned, I think the duty regarding maintenance is contractual as it relates to Polk County. We're a licensee, not an owner, so our duties are contractual, and those say very specifically that we're only responsible for maintenance costs. The railroad goes out there, they maintain the entire crossing. If there's asphalt in the middle, they'll send us a bill for that, but we don't touch it. And respectfully, I disagree with counsel for the railroad about not having a shred of evidence, and I'll point the court to page 1340 of the record. And this was the testimony from Polk County's representative about that issue. And he said, it's just a very short 2 sentences. So if there's an issue there with their rail components, they would maintain that at their expense. But anything outside of the railroad ties, they would maintain at the county's expense. So that's what the county would reimburse him for. So with all respect, there is evidence in testimony, but
Counsel, sorry to interrupt you.
Yes, ma'am.
Is it your understanding that the trial judge ruled that your client does not have a duty in this case, or was the trial judge truly making a causation determination based on what the experts testified to? And I understand your argument to be either that the expert that
Yeah.
Dr. or Mr. Fisher was testifying based purely on speculation, or that it was the improper stacking of inferences. But is it true that in your mind that he really just ruled on causation?
I would like to think so, but there is a little dicta in there where he talks
With the
about
duty.
the scope of maintenance, and that's what upset me, because when this motion was filed, it wasn't directed at all to the county, it was directed exclusively to the plaintiff. And it says in here, and I'm reading from CSX's motion, at best plaintiff may establish Mr. Gossage fell in the vicinity of the railroad crossing. However, she is unable to establish Mr. Gossage fell because of the railroad crossing. So I took it that this is a motion directed exclusively to the plaintiff based on that theory that they can't prove how this person actually fell through overbraking or through some other error, but not necessarily because of the condition of the road. So I merely joined in that portion of it, not thinking that the judge would issue an order basically declaring, well, he didn't really declare, but he did read the contract and said the contract speaks for itself. But then he goes and mentions that it's undisputed about where the scope of duties was, and that's not the case at all.
But certainly you're happy with the judge's, with the outcome, right?
Yeah, I mean, I would like it affirmed, but only because it's based on speculation as to what effect, if any, the roadway had on this, because they can't establish where he began braking, and what effect the undulation or the slope may have had to it. And to I think it was Judge White that brought up the slope point. This was a reconstruction in 2002, and DOT was involved, and all of their specifications were attached to it. So on behalf of the county, you know, regardless of who constructed it, they constructed it according to FDOT specs. And I think that was one of the criticisms that
But counsel, who owns the road? Does FDOT own the road? Does the state take the road, or does your client own the road?
the road leading up to the crossing
Correct.
is owned by the county.
Okay.
But, there was a mention that, and I think, counsel for, the appellant said that we maintain, or we built up to the, tie. I don't think that's correct. I think every time this crossing has been redone by CSX, and it's been done a few times over the years, they do the work. They send us a bill for whatever asphalt was spent in between the ties. And that's it for the county. But I wanted to mention the slope part because, and this gets back to your argument, is this a causation argument or not? The slope was built according to FDOT specs in as far as that 2002 agreement goes. There's no evidence from their expert that there's any problem with the slope. Maintenance, as you described, is this a maintenance or a design issue? Well, I mean, it was designed according to FDOT specs, and there's no evidence from their expert that there was, somehow some maintenance issue. So I think we have a better argument than actually CSX for getting out of the case based on speculation, just because there isn't any evidence of some failure and negligence on the slope leading up to the crossing.
Council, 5 minutes goes pretty fast.
Boy, that was
I
quick.
don't know
Yeah.
if any of my colleagues have any other questions.
Okay, thank you.
All right, thank you.
Well,
All
Your
right,
Honor,
council, I'm going to give you a total of 10 minutes for the extra argument that your opposing counsel got in total, as best of my recollection. You don't have to use it all, but I'll give that to you should you desire. All right.
Thank you, Your Honor, for both giving it to me and telling me I don't have to use it all. I really just want to highlight a few points, and I want to start with the expert testimony because I spent way more time on duty first time I was at the lectern. We have to consider where this whole idea of overbreaking came from. And it came from the railroads shifting theories on what caused this crash. They filed a motion for summary judgment saying plaintiff can't prove it had anything to do with us because it was most likely the failure to maintain the motorcycle appropriately. And we think the plaintiff or the plaintiff's decedent had a bicep tear, which caused him to lose control of the handlebars. Mr. Fisher signs an affidavit, gives his opinions, and then there's a new motion for summary judgment with the defense expert opinion that no, it was actually overbreaking that caused. So Mr. Fisher didn't address overbreaking because nobody had ever said overbreaking before. It was entirely a defense theory. So there are a couple reasons why the trial court should not have held plaintiff to the burden of completely disproving this overbreaking theory. One, it's just not a presumption that a plaintiff has to overcome. There's no underlying presumption that the accident was Mr. Gossage's fault, which is really what overbreaking posits, right? Overbreaking means you applied the brakes improperly.
I think what opposing counsel was stating, if I'm correct, is that there's an impermissible stacking of inferences and a speculation done by Mr. Fisher, and that it cannot be purely speculation. I think the stacking of inferences is nuanced with regard to expert opinions, but he's saying, oh, it's purely based on speculation. So can you show us why it's not purely based on speculation and how this expert witness can get over their theory that it's an improper stacking of inferences?
A couple things, Your Honor. One, the idea that Mr. Gossage braked as normal is supported by the circumstantial evidence. And I know Mr. Mortara did not say Mr. Gossage braked as normal, but the description of everybody involved here was that they were experienced motorcycle riders. They were all approaching this crossing at about the same speed. And the fact that Mr. Gossage had ridden motorcycles for a very long time, had not washed out at railroad crossings or at any other point. And Mr. Fisher's analysis of the skid marks and the role that the so-called geometry and the ramp played in this all lead to the conclusion that overbreaking was not the sole cause of this accident. And I want to emphasize that last point because that's really all that the plaintiff is required to do. We don't have to rule out completely that Mr. Gossage's negligence contributed in some way to this crash. What we have to do is show through some admissible evidence that one of the causes, one of the legal causes, was the failure to design and maintain this crossing. And that can happen even if Mr. Gossage did overbreak. So Mr. Fisher's opinion is that he did not overbreak, but even if that were rejected, that wouldn't affect the salient opinion he has that one of the contributing causes to this crash was the condition of the crossing. And that was the main point I wanted to make there. In addition to the fact that, as noted already, the stacking inferences analysis does not apply to expert opinions, and the Zach versus Centro case could not illustrate this better. Almost the precise same thing happened, except I believe it was a JNOV in Zach and not summary judgment. But the court said, the trial court said in Zach, this expert testimony was insufficient to create an issue of fact because the expert disregarded all of the witnesses and documents saying that there was no negligence and it didn't cause his injuries, and instead drew these inferences from circumstantial evidence that the defense did cause these injuries. And I think in that case, it was the allegation was a nurse removed a catheter while the cup was still full. All the witnesses said the cup was empty. The documents said the cup was empty. The expert said, I think it had to be full based on the circumstances of how this all happened. And the trial judge said, that's not good enough. And the second district reversed on that. That was followed in the Dumigan case from the, I want to say, Fifth District just a couple of years ago. The other case that I think really informs the outcome of this is the Bond versus Columbia County case. Now, that's a little bit different because the trial judge even made a Daubert ruling in that case, which the judge here did not. But the appellate court in that case said that in making inferences, the expert is entitled to rely on any view of the evidence. He can reject portions of the record, he can accept other portions of the record and draw inferences from those portions that he accepts. That is not a Daubert problem, it is not a summary judgment problem. And that's what Mr. Fisher did here. He did a site inspection, he reviewed witness statements, and he is an accident reconstructionist who applied normal standards of accident reconstruction. So I just disagree with opposing counsel's characterization of how this should even be analyzed, because echoing the trial court, what the railroad is saying is you have to look at this first inference of overbreaking and overcome that conclusively. And because that's not a presumption and that's not an initial inference that's material to the opinion anyway, that's just not the analysis that the trial court should have employed. And for that reason, it should be reversed. Now, Judge White, I promised you that I would look at a couple things when I got back to my table. I reviewed the motion for summary judgment that Polk County, or I'm sorry, that CSX Transportation filed. I did not see anything raising the issue that the grading of this was FDOT's fault and had nothing to do with the maintenance or anything that the railroad of Polk County did. Because it was not, in my view, raised in the motion for summary judgment, I don't think that in the trial court we made a record on how this came about.
So to make sure I'm understanding, so you agree, and based on CSX counsel spending a lot of time talking about it, that their argument was, we don't have a duty because we're not responsible for that area at all.
Right. That was the argument, and that's what we focused on. I will say that, Polk County's answer brief on page 18 talks about the 2002 actions and what CSX Transportation did, and what Polk County's financial responsibility was. On pages 2835 to 2836 of the record, Mr. Fisher discusses how FDOT identified problems with the grading, and I think he said they suggested a grade out, which I think we could have developed further if this issue had properly been raised. To note that by FDOT suggesting a grade out, CSX Transportation had the opportunity, or Polk County, if they continue to contend it was Polk County's responsibility, they had the opportunity to do that grade out in response to FDOT's suggestion.
And I'm sorry, what portion were you citing in Mr. Fisher's testimony?
It's on pages 2835 to 2836 of the record on appeal. And Your Honor, I want to stress that that's just what I was able to come up with right at this moment. I think if it had been raised in summary judgment, we would have had more to say on the subject. But the trial court definitely did make a ruling that the railroad did not owe a duty. And what it did not do is make any ruling that Polk County did or did not owe a duty.
Do you think that the trial judge's analysis with regard to duty was correct, and whether it matters ultimately for their purposes might be up in the air, but with regard to sort of this easement and the dominant estate?
The trial judge did that because I noted it in our response to summary judgment. And, in hindsight, I regret that because I don't think it's
Okay.
material.
Thank you.
But, the idea of the serving and dominant estate, that only comes up when one party owns the property in fee and another party has an easement over it. And then there's pertinent easements and easements in gross. But here, the only property records that anybody knew of were CSX Transportation owns this whole area, the whole relevant area where this occurred. And any duty on Polk County would arise solely under the contract.
Where is, when you say the whole area, what document are you referring to that talks about who owns this whole area, whatever you're referring to there?
There's the initial license agreement that talks about, that describes the crossing as a whole, as the property of CSX Transportation.
You're talking about the 1932 agreement?
Yes, Your Honor.
Well, yeah, it refers to this blueprint, but I couldn't find that blueprint anywhere in the record.
Yes, and then Mr. Fisher's testimony, based on his review of the property records, he gives the number of feet extending out at the property records.
I'm sorry, who's that?
Mr. Fisher.
Mr. Fisher?
Yeah.
Okay, and where is that in the record?
Oh, good Lord, Your Honor. I do not know. I know he.
So
said
he examined property records? Mr.
He
Fisher
looked
did?
at the appraiser's records.
Oh,
So
okay.
if I were,
The
if
Polk
I-
County property appraisers?
yes, if I were to look at this for Your Honor, I would do a word search for appraiser. That's how I would find the answer in Mr. Fisher's deposition.
All right, thank you.
And I used more time than I anticipated, but I wanted to thank Your Honors for the opportunity to argue this case.
Any other questions? All right, thank you, counsel. All right, thanks to all counsel for preparation and helpful argument for us. Thank you very much.